In every age, there exists a small circle of people, guardians of ideas, who alter the trajectory of civilization by understanding not just what an invention is, but what an invention means. Today, you join that circle. Because to master a patent is to master the architecture of innovation itself. For the next few moments, prepare to see patents not as paperwork, not as technical burdens, but as instruments of power, crafted with precision, defended with ferocity, and revered for centuries. Picture the world before inventions had guardians. Napoleon once said, "Imagination rules the world." But imagination without protection is merely hope. It was not until the mid-19th century that the world realized something profound. Innovation thrives when inventors are rewarded. Thus, modern patent systems emerged, codified, structured, and elevated into legal mechanisms that could turn a lone idea into a global economic force. The USPTO, in its Manual of Patent Examining Procedure, defines a patent as a right to exclude others. Dramatic, isn't it? Not a right to create, not a right to sell, but a right to exclude. Patents are anti-competition devices, a temporary state-granted monopoly. This is the first truth only insiders understand. Every invention must pass through 3 gates. They appear simple, but they guard the entire kingdom of modern innovation. USPTO Utility Requirement 35 USC, or 101 states, the invention must be useful. Useful to whom? Useful how? Useful in what context? These questions are not trivial. They are foundational. In academic philosophy, Aristotle taught that everything has a telos, a purpose, an end, a destiny. Modern patent law adopts this ancient principle. Your invention must do something, must change the state of the world in a meaningful way. A device that achieves nothing inheres no right. "35 USC 102 speaks of novelty. The invention must be new, never publicly disclosed before your filing. Novelty is a race against time, a race against the world. One forgotten blog post, one conference slide deck, one cafe discussion overheard, and your invention may become prior art, fatal to your patent. This is why scholars describe novelty as the metaphysics of newness. If it exists, written, spoken, published, posted, your claim collapses. Here lies the true battlefield. 35 USC 103 refers to non-obviousness. Your invention must be a leap, not predictable, not routine, not the result of ordinary engineering. The USPTO describes this as a difference that would not have been obvious to a person of ordinary skill in the art. MPEEP 2141. Inventors often struggle here. They whisper, "But it is obvious." No, it's obvious to you because you climbed the mountain. The world has not. Thus, this gate separates mere improvement from innovation. Let me reveal something few inventors know. Patent examiners are not judges. They are not bureaucrats. They are scholars. Each examiner is a gatekeeper of a specific technical domain. Quantum cryptography, semiconductor physics, biotechnology, mechanical engineering, artificial intelligence. They evaluate your invention using doctrines derived from MPEP, Manual of Patent Examining Procedure, case law, Graham v. John Deere, KSR via Teleflex, international treaties, WIPO PCT TRIPS agreement, scientific prior art. It is an academic examination, not a clerical one. And here lies the drama. A patent is born from argument, persuasion, artful claim drafting, strategic amendments. The file history, known as the prosecution record, becomes a chronicle of intellectual warfare. Every patent has two souls. 1. The description, the story of the invention. 2. The claims, the legal boundaries of your kingdom. Claims are extraordinarily powerful. They determine who you can sue, what products you control, what technologies you can block, who must pay you royalties, and what future markets are yours. As the MPEP explains, claims define the invention for which protection is sought. MPEP Section 608. Too narrow, and competitors walk around you. Too broad. And the examiner rejects your patent. Drafting claims is the artistry of law and engineering fused together. This is where true patent counsel earns their reputation. Let's widen the lens. A patent filed in the United States applies only to the United States, but innovation is global. Enter the Patent Cooperation Treaty, PCT, administered by WIPO, a system allowing you to file one international application that can later be pursued in over 150+ countries. The PCT does not grant a global patent. No such thing exists. But it grants something more valuable: time. Up to 30 months to decide where your future markets lie. WIPO, the World Intellectual Property Organization's applicant guide, calls this a unified procedure for filing patent applications to protect inventions internationally. This time is oxygen for startups, oxygen for strategists, oxygen for visionaries. The Wright brothers didn't win because they flew first. They won because they patented first. Their 1906 patent was not about wings, not about engines, not about altitude. It was about controlling flight, the method of movement, the heart of aviation. Their competitors had planes, but the Wrights had claims. And the aviation world bent accordingly. Innovation bowed to legal architecture. Here is the suggestion that I offer to you, of course, mindful of the fact that I am not your lawyer, and independent legal advice is required for your particular matter. But this is the same recommendation that I give to founders, luxury designers, inventors, and visionaries. 1. Patent the essence, not the ornament. Focus claims on the core functionality. 2. Build a portfolio, not a single filing. Empires are not built on one stronghold. 3. Use the PCT to buy time. Strategize globally, act deliberately. 4. Expect rejection. Examination is academic combat, not a sign of failure. 5. Never draft alone. A master patent requires legal precision, technical intelligence, and strategic foresight. And so, my brilliant creator, a patent is not merely a document. It is a declaration, a thesis, a shield, a throne. When crafted well, it becomes your legacy. When understood deeply, it becomes your power. Now, I urge you to take to the comments and share your thoughts about this discourse on how a patent really works. Would you like to hear more topics on this? Tell me, was anything on our list familiar to you in your experience with intellectual property? I am your friend for this journey into the world of innovation, and now that you know how a patent truly works, the real story begins.